Ney Walker, the successor of Ney McCormick here, for presenting a lecture, and especially the Perlman lecture, because we know very well the link that exists between Ney McCormick and Perlman, and I'm happy that we continue somehow this tradition of exchange. So, of course, everybody knows Ney Walker is professor at the University of Edinburgh, and this year he gets the International Franklin Professorship. He will present some of the thesis he developed in Intimations of Global Law. Of course, we will have a short discussion today, but we will have a lot of time to discuss Ney Walker talk tomorrow morning, since we are stuck to a schedule today, because we have to move not far from here, but we have to move after the lecture and the discussion of today for the cocktail. So, Neil, thank you very much for coming, and
about 3 hours.
okay. So you have the floor.
Okay, thank you. Thank you very much, Gregory. Thank you very much to the Centre for inviting me. It's a great privilege to be here. As Gregory said, I did not know Perlman personally, but my predecessor did, and in fact his penultimate book on rhetoric and the rule of law is in many ways dedicated to the memory of Perlman, and he's someone with whose work he engaged in a number of ways on a number of occasions. And I'm not going to stretch things by making links between Perlman and anything that I'm doing, but I think we should keep in the back of our heads notions of universal audience, etc., when we're thinking about ideas of global law, because I think they're far from being irrelevant. So I find myself in a slightly awkward position, because in some ways there already have been some intimations of my book on Intimations earlier today in the two excellent talks by Larry and Maria, and also by Gregory in his introduction. So I don't necessarily want to, and I don't have time to, say everything which is germane to my thesis over the next 45 minutes or so, but I think it probably is important that I do go through some of the rudimentary background and also begin to answer some of the questions which were raised, or at least raise these questions again and give some preliminary indication of how I would go about these. I would say that actually since I wrote this book, and I finished it about 2.5 years ago, apart from 2 or 3 articles and a couple of responses, etc., I haven't done much in the area of global law. And in fact, it's not what I've been talking about in my series of lectures at KU Leuven, where I've been talking about reimagining the European polity in the context of a Frankie professorship. I think that's partly because I'm stuck. I've reached a point in my thinking about global law where it's not that I do not see it's a rich field, but it seems to me it's a rich field for legal sociologists. It's not necessarily a rich field for someone who's trying to do the type of conceptual work that I've done. I feel that I've done what I can. There may be things I can do beyond that, but I'm very, very much in listening mode today and tomorrow, because I want to find out what other people think of this project and how, if at all, it might be taken forward. So that isn't supposed to be negative, by the way. I think global law is a fantastically interesting area. It's just that sometimes when you spend all your energy on something for 18 months or 2 years, then sometimes you feel you don't have much more to contribute to something until you hear other people's contribution. I would also say that I have been reading quite a lot from the people in the centre over the last few months, and I realise that we have a lot of common ground. I'm somewhat embarrassed by that, because largely I did not refer to this work in my book. But again, I'm also reassured by it because it suggests that people coming from quite different intellectual traditions can nevertheless arrive at some of these same conclusions. So let me start with just a couple of methodological pointers about looking at law beyond the state in some basic sense. And I mention this because to some extent they inform or did inform my approach when I was writing the book. First of all is this sort of countervailing notion that basically what we have to do here is we have to think about law as against the state-centered flow. So it's not that there's all sorts of complicated ways in which global law folds back into national law, and we'll talk about some of these. But if you want to take seriously the idea of law beyond the state, then you have to tackle head-on what it is about the orthodoxy of state-centered law, or a certain conception of state-centered sovereigntist law that you want to somehow depart from or challenge or whatever. Okay? And I think that's something that all work in this field has in common. The second thing is that any work here has to be very, very inclusive, right? It has to be inclusive. That many of my critics from a more orthodox state-centered perspective have basically marginalized what I've said by what I would call definitional fiat, by saying, well, the sorts of things you're talking about aren't really law, right? There's some other type of regulation or governance, etc., etc. And of course, the point about that is you have to be careful about definitional fiat, about these sorts of stipulative definitions, because they often betray the particular perspective that you come from. So if you have a state-centered conception of law, which has to have a particular pedigree, a particular notion of legal system, etc., etc., then, you know, it will not be surprising that there are many, many aspects of global regulation which are not necessarily recognized within that perspective. And it doesn't prove anything other than the particularity of your own definitional and your own framing assumptions to say that what the other party is talking about is not law. So we have to understand, and I think this came through very, very well in both of the previous talks, we have to understand that, you know, if we're going to make sense of this phenomenon of global law, it's going to be something which is very inclusive. It's going to be diverse in form, in function, in source, in resource, etc., etc. And something I can see certainly in the work of the Perlman Centre on this is that they have a very, very broad, wide-ranging, pragmatic approach to what should count as global law, and I entirely endorse that. However, my third point, economy of explanation. You know, there's an old joke, you know, that the best map of the world may be the world itself. Okay, it's a great, you know, the best map of this room is the room. But of course, in economy of explanation, is precisely what we're trying to do is to find something, you know, which is more concise, which gets to the heart of the matter that we're trying to explain, which doesn't simply reproduce. I would say that a lot of work in the sociology of transnational law is rich in its complexity, in its diversity, in its range of explanation, in its range of empirical detail, etc., etc. I have learned a huge amount from that body of work. I don't necessarily come away from a lot of that work understanding what the prime movers are in the development of global systems of regulation, because I feel that in many cases, so bewildering is the diversity which has been accounted for, which has been described, that we're not really understanding at a more general level what is going on. That's not a criticism, it's an observation. You need both. You need the map, but you also need people who attempt some kind of broader explanation of it. So there's a sense in which the countervailing approach, the inclusive approach, and the economy of explanation approach are all vital to what I thought I was doing when I set out to write this book. Okay, right. So the countervailing approach, let me just, this is a slightly, I apologise in advance that I'm going to make some, because of limits of time, what is quite a complex book, I'm going to provide some reductions and simplifications of what it is I'm trying to say. So I apologise in advance for that. But what I want to say is that people often talk about the Westphalian duo, you you know, the idea of the national and international system as being the twin legal orders of the state-centered modern age. Internal sovereignty taken care of within constitutional law and other lower forms of law, and external sovereignty dealt with through the prism of international law. And what we have, I think, as we move towards something like global law, is the overcoming of three divisions. The internal divide between states, the internal-external divide between the state and the international, and just as importantly, perhaps more importantly, as you'll see from my thesis, the external-external divide. That is a divide between the external boundaries of the state-centered international system and a wider horizon of global legal relations, which includes other non-state legal sources, actors, and subjects. Okay? So what I'm saying is that within the world that we're looking at from the perspective of global law, there is an overcoming of all of these barriers. There's a greater porosity, there's a greater malleability of these sorts of boundaries. So there's three sorts of boundaries which are overcome. Okay. Now, let me then say what, for me, the structural context of global law is. Okay. And so, as I'm going to explain in a moment, I do not want to include all of transnational law, which I'll also define in a moment. I don't want to include all of transnational law, all law that somehow crosses borders in terms of the actors involved and the events involved within my definition of global law. Right? Now, this is not an imperial grab in my part. I do not care whether anyone accepts my definition of global law. I really don't. Right? What I want is people to accept that what I'm talking about is important, regardless of whether you call it global law or global law, whatever you want to call it. There's something going on there, right, which is important, and it's only one aspect of transnational law. And obviously it has to be looked at, as we'll see, in close interaction with transnational law. But when I'm talking about global law, I'm talking about a specific thing. Now, I say that because at the very beginning of this, I had an argument with William Twining, who said, no one should talk about global law. It's a terrible term. It should be excised from our vocabulary. We should never talk about global law because it's so imprecise. It might mean law which you get at the level of the globe, from a global source, the UN, etc., etc. He said, but that doesn't tell us anything interesting about the world. What we want is to grasp the diversity of different forms of transnational law. I'm all for that, but the way that I'm talking about global law is actually quite specific. It's a very specific thing that I'm talking about. And this is it. This is the structural context of global law. It happens in response to the sheer range of forms and regimes of transnational law, overcoming the three divides which I just talked about, and leading to the decentering of state sovereignty as a key global meta-principle of legal authority. Okay? So what I'm suggesting is that there's been a displacement of this meta-principle of legal authority. Now, I'm not suggesting that this meta-principle of legal authority was always dominant, was always hegemonic in every respect. I'm not telling a golden age story of modernity. It's a very complex story. We'll come back to some of these complexities in due course. But what I'm saying is that there has been a shift. There's been a shift away from the state sovereignty as being the leading paradigm of legal authority. And what we have in global law is an attempt to provide new ways which are both convergence promoting and divergence accommodating. Again, I'll come back to what these mean in due course, of making global claims to authority other than through the global meta-principle of sovereignty. So they're new framing mechanisms. Okay? And that's what I'm concerned with. You know, my concern with global law are things which reimagine the globe. Gregory earlier on helpfully put up my different images. And all of these images, the segment, the thread, the chain, etc., are all things which you can put around the globe, right? They're things which actually respond to the overcoming of the three boundaries by imagining a new outer boundary in a way that Maria was talking about, something which goes beyond, you know, our existing boundaries, but which still nevertheless provides a new frame for law. And these alternatives to sovereignty may take the form of explicit global reframing claims, or more grounded legal or quasi-legal initiatives which simply imply new global reframing claims. Okay? So these things can be more or less explicit. They can be more or less clearly articulated. Okay? Now, let me move on. Oops. Sorry. This something has come up which is problem sur la news. Okay. Okay. Is that because I didn't move it quick enough?
No, but I think that's right.
Sorry? Ah, yeah, okay, I should just, yes. Okay, right, okay. Right. Okay, right. So let me then come on to what is my stipulative definition of global law. It might not seem very much, but every word or every part of this sentence actually matters. So it's any endorsement of or any commitment to the universal or global in general, two different things, warrant of some laws or of some dimension of law. Okay? So that's the claim which I'm making. So try to hold that in your mind. That's the nature of the claim of what global law is. So we'll now go on to what that means. So what it means, first of all, what it doesn't mean is it doesn't mean that global law is tied to any particular source or any particular pedigree. Okay? It's about where it goes to, not where it comes from. So it does include, but is not restricted to, what you might call planetary level law, UN law, world order treaties in the area of climate change or whatever, formal rules of international law, use cogans, etc., etc. It also can come from single site, e.g. national sites where your claim is made of universal jurisdiction, whether it be Belgium historically in the area of criminal law, or America in the area of alien torts or whatever, or it could be regional, EU, in terms of its attempts to broker universal standards in a whole range of areas, from climate change to aircraft emission controls, etc., etc. But probably most prominently is something which, and this links to Maria's point about it not having a clear author, is something which operates as a kind of intersite flow between states, but also other private or hybrid sources, and also the jurisgenerative source of legal academics and practitioners. So when I say between states, etc., what I'm talking about here, and we'll come on to look at some examples, is the way in which, under global constitutional law, there is an understanding that there is a circuit of normativity which moves between different sites, national and international, where there's a process of borrowing going on, etc., etc., where each specific claim is somehow reinforced by the other claims. There's something cumulative, there's no obvious authorship, but nevertheless there's still a kind of process of normative development. But also the jurisgenerative source of legal academics and practitioners, I do think, this is very, very important here, is linked to the fact that in the context of the structural situation of global law, the demise or the decentering of sovereignty, there is a space for new innovation. We've always had innovation, we've always had people thinking about global law before, to answer one of Gregory's points. But I would say there's an intensification of that in the new age, which is different, which is differentiating from the past and which has to be taken seriously. So quite often legal academics and practitioners as well are involved in this. And what I talk about in the book is is global lawcraft, and I talk about a continuum of global lawcraft, and saying that part of what's going on here, and there is an interesting sociology of this, is that there are some people who are actually theorists and practitioners at the same time, or they move between these. We all know about arbitrators who are also legal academics, about judges who are also arbitrators, about legal academics, for example, like my friend Miguel Maduro, who is one of the authors who started the idea of constitutional pluralism. He was also the Advocate General in the Caddy case before the European Court of Justice. So there's a lot of flow between these different sorts of actors. Okay? So my point is, though, that global law comes from a lot of different places. It doesn't come from any particular place. That's not what defines it. What does define it is where it goes to. It's either universal or it's global in general. It covers all affected, not just states, wherever affected, limited only by the material jurisdiction of the rules we're talking about. So the claim is either universal, without personal jurisdictional limit and so implicitly global, or increasingly it's consciously planetary in coverage and so explicitly global in general. You might say, what's the difference between these two things? I think it's an important difference, because one of the ways in which historically we've always had global law is that we've always had a tradition of natural law. We have a tradition of natural law, at least from Aristotle, going into the Thomists of the Middle Ages, where there's always been a notion of the universalism of global law there. But it's by universalism which has been somewhat incurious about whether or not that law actually globally applies, for all sorts of reasons to do with imperialism, lack of knowledge, etc., etc. What we have today, what we tend to have today, is in some ways a more sceptical approach towards universal ideas, but also more of a genuine interest in what I call global and general ideas, where the point is the globe itself is imagined as some kind of polity of mutual dependence, in the Kantian sense of being unavoidably side by side, in that sense in which there's a mutual dependence and therefore a requirement for some sort of common legality. That's a different thing, jurisprudentially, from a universal claim. But what you have, I think, in today's global law are both sorts of claims, both the universal claim, which is implicitly global in general, but also more specific global and general claims in areas such as climate change, etc., etc., where the globe is imagined as a single community of risk or a single community of fate or whatever. So not only are unrestricted to any specific source, but also in principle unbounded. That's the idea that I'm trying to get at here. So what is legal about global law? So I apologise for the way that I'm setting this out, because it seems like I'm somehow giving you all the technical details before I give you the substance. I could do it the other way around, but it probably wouldn't make sense that way. So it's probably best that I try to explain all my qualifications in advance of actually talking about it. Some laws are dimension of law. So let's again parse that phrase. Laws are dimension of law. So what I'm talking about here is either positive law or a jurisgenerative framework for positive law. For example, we might talk about a global rule of law, or the sorts of ideas that you get within a Habermasian tradition about a universal code of legality, where you get are notions which are actually prior to any notion of positive law. So, again, in preliminary answer to one of Gregory's questions, the way in which I'm looking at global law, the reason why it has to stand back from the empirics is one of the things I'm looking at are precisely the way in which empirical trends are being reanalyzed, reconceptualized by different people, by different actors, academics and otherwise, who are actually trying to develop new frames for somehow containing, making sense of the diverse range of empirical developments within transnational law. Some laws, the emphasis here on the some, because again, what I'm trying to say, and I think there would be general agreement here, is that when you're talking about global law, you're not suggesting that all law suddenly is global. There's still lots and lots of local law. And what global law is doing is it's providing a kind of globalizing frame and jurisdiction for other local laws. In fact, often there's a kind of dialectical process going on here, because the very idea of a global frame is often inspired by, provoked by local developments. But then the global frame is used as a way of making sense of, developing, thinking through these local developments. Think about human rights law and the way in which human rights law constantly moves between the local and the general and back again. So the global dimension is not about uniformity across the globe in law. It's about the way in which global mechanisms frame the diversity of law without necessarily imposing a uniformity on it. Right, final definitional point, the transnational law and global law. If you, Philip Jessupp's famous definition of transnational law regulates all actions and events that transcend national boundaries. So, I'm not saying transnational law and global law are discrete categories or nested categories. One is not imposed upon the other, or even necessarily mutually contested categories. They're just overlapping categories. Global law covers some of, so global law to some extent is about law which is inspired by or is related to actions and events that transcend national boundaries. But crucially, it doesn't have to be. Global law also covers some law that merely migrates between states without referring to actions, events in transnational legal space. But it's a case of people borrowing from each other and saying that on the basis of good practice in another jurisdiction, that will also be adopted in this jurisdiction. So what's happening there is that the transfer is taking place only at the level of normativity, and it's not necessarily to do with the location of activity in transnational legal space. Okay, when is global law? Again, this is important. We talk about global law is an endorsement of or a commitment to legal development. So it's not merely an observation or aspiration. One of the arguments I had with William Twining is he said, could you please stop confusing the idea of global law as a field which we spectate and we look at, and global law as a practice? And my response to that is, I'm not confusing them. I'm trying to say that there is a new and interesting continuum there between like you might call concrete doctrinal articulation on the one hand, and a kind of committed reframing of law on the other hand. So you're not doing global law if you merely observe stuff. You're not doing global law if you merely talk about some blue skies aspiration, which has no traction in existing reality. You're doing global law if you somehow get involved in this business of intimation. And that's what's central to my title. Global law possesses an intimated quality. It's something which is already suggested in practice, but it's also projected forward from that suggestion. So it's an intimation both in the sense of something which is suggested passively, but also it's an active intimation. On the basis of that suggestion in practice, there's an extrapolation from that and a development of a fuller idea of global law. So it's suggested, it's projected, it's contestable, it's always in the process of becoming, it's more than aspiration, but it may well be less than settled law. Or to the extent that it's settled, it's always subject to a degree of unsettlement. Okay, give me a second. So, as I said, global law, if you go into the particulars of it, involves different images of the legal world beyond the image of, let's call it the box matrix of the sovereign system. Think of a box matrix. And that, in some way, is the way in which the world is imagined legally within the sovereign disorder. And what you have instead of these, or alongside these, because, of course, the box matrix is still there, and it's still significant, it's still one way of framing the law. What you have alongside these are a range of what I call convergence promoting approaches and divergence accommodating. So the convergence promoting are based upon conceptions of the legal world as a hierarchy or as a framing singularity. And we'll see the images here are pyramid, umbrella, vessel, also a thread. Or it's divergence accommodating, based upon a conception of the legal world as a heterarchy or plurality. And here are the different images, the chain, the segment, and the flow. And again, also the thread. Okay? And what I do, and what's the large part of the book actually, and the bit that I don't really have time to talk about very much, but I'm happy to talk about in questions, is to actually develop these different sorts of species. Now, one of the points I want to make here, and I think it's actually quite important, is that it's not